Good. So can you see my screen, both of you?
Yes, I can.
Yep. Okay. So what we want to take a look at is two separate chapters. The first chapter happens to be on, in this case here, the legal system in Canada. And it's an important concept. And the second one happens to be on human rights. And we'll take a look at the Human Rights Code in several different elements. The first one we're going to look at is the foundation of Canadian law. This is very different from British law, and it is extremely different from American law. They are actually not the same at all, especially when you take a closer look into them. So we want to take a look at this particular chapter and some of the elements within it. So the source of employment law, this particular set of rules has changed astronomically through the last 20, 30 years. It really has made some major inroads into fundamental rights with people. In 1982, as you probably are aware, Justin's father, Pierre Elliott Trudeau, actually broke the rule, per se, in the political arena and gave Canada its constitution. This is something that virtually every politician, and I do mean every politician, was very much against. They did not want you to have rights, especially enshrined within a constitution. Before that, we actually had a bill, and a bill can actually be withdrawn by a politician, but constitutional rights cannot be. And that's one of the reasons that there was so much turmoil back in 1982 was because of the Constitution and the changes it made to the legal structure. So as we look at this, keep in mind a lot of these things are relatively new and some of them very ancient. So there are two main sources of employment law. The first one is by statute. So the government actually in Parliament introduces brand new bills. Those bills go through the Senate to evaluate the, let's say, the way that they're written, to make sure that there are no loopholes. Once they're returned to Parliament, they become enacted as an actual law. So statute law is created by Parliament. The second one is common law, and this is something that is created through history. As a particular justice or a sitting justice actually determines what an outcome should be, it then incorporates a particular set of rules, and they're based on precedent. So if a particular judgment was acceptable to the people during a particular period of time when it was introduced, then all judges from that day forward will use the same outcome. So common law is based on precedents. So laws developed over the years through court decisions, whatever the decision was, and if people were accepting it, then they would actually base it on precedents. So just to give you a little history behind that, as you probably know, there was no such thing as a free person anywhere, especially in the British Empire, the French, the German, the Spanish, and we could go on and on and on. But fundamentally, everyone was property. And they were the property of, let's say, kings and knights and people who were in the courts. Those were the people who actually owned things. Everybody else was just property. And of course, there was a necessity because of some of the problems in hamlets and villages that they had to have different individuals dealing with the legal system. Give me 1 second, I have to close the door. That's better. And some airplanes going over. So what was happening was a lot of problems within some of those little villages because of the sheriffs. Sheriffs were actually appointed by the knights and also by noble people who actually owned large quantities of land in the villages and the cities and towns that they were occupying. And what was interesting was they all had their own corrupt way of dealing with issues. If you stole the chicken, you'd probably lose your head, and your children would be put into servitude. And it was really kind of nasty. If you, let's say, didn't pay your taxes on time, they'd burn your house down, murder your family, and you'd be expected to find some way of paying them. It was a very corrupt period of time. So the crown actually created, through the exchequer, the roaming judges. And the roaming judges were actually sent out by the crown. It was a way of quashing some of the uprising that was taking place in England and also in France at the same time. So as a result, they actually were finding that sometimes people were happy in a village with the decisions made by these roaming judges, and therefore they decided to use the same outcome anytime they ran into a similar situation. So if, for instance, someone didn't pay their taxes, then there was a certain outcome. Everybody in the village was happy, and therefore the other villages would do the same thing. They'd have the same outcome. And this is what precedence is based on, that anything of value was carried on and used exactly the same way. Now, the French use a different system, and we use it in Quebec, and that's a codification. So it's based on civic law. It's a little bit different than common law, but it's based on codification, and it's the same philosophy, though. Types of statute law, it's important to recognize these because we have a philosophy in Canada which is called paramountcy. Paramountcy means the higher court always succeeds. In other words, if you had a court case, let's say in a municipality, and you weren't too happy with it, you could actually request that it be retried. Well, if on a higher level, they had already tried a case similar to this, and they had a different outcome, it would be the higher court that made the decision, not the lower court. We call that paramountcy. So the head of the family, the head of the nation is the federal government. And therefore, federal law is the number one, the highest level in Canada. As you know, the Supreme Court, which represents the federal level. The national parliament has the power to make all laws to keep peace and order throughout the entire country. It has that fundamental right, except for subjects assigned exclusively to legislatures of the provinces. Now, that's called a Division of Powers Act, but fundamentally, the federal government has the right to withdraw that. It does have the power to withdraw all authority from the provinces. Of course, that's never going to happen because we live in a very specific type of environment. Provincial law, which is beneath. So once again, we have that paramountcy situation that if a province votes on something, or let's say a court decides something, and you decide to appeal to a much higher court like the federal, and the federal doesn't agree with the provincial, federal wins. Okay, you will always go to the higher authority. And therefore, the higher authority being federal, it's called paramountcy. In other words, releasing to the higher authority. So provincial legislature has the power over provincial taxation, natural resources, prisons, hospitals, municipal, anything that deals with the local jurisdiction. Every province is very different. I think I've explained that before, that sometimes it's easier to deal with another country than it is another province because of the rules and regulations to protect the people within it. So jurisdiction of each province is very different, and therefore taxes are different, etc. However, when it comes to taxation, though the province determines the taxation, the taxes are paid to the federal government, which then has something called transfer payments where they pay the provinces back according to the budgets of each province. Some of the most important elements within a provincial government is the protection of the individuals within its jurisdiction. And as I said a moment ago, each jurisdiction is just ever so slightly different from each other one. They all have their unique characteristics, and every province has different needs. So, human rights code is one of the things covered by, let's say, the Ontario government, Employment Standards Act for people within that particular province. And this covers all kinds of different issues. Also, the occupational health and safety of the province is different from other provinces. And workmen's compensation, so Workplace Safety and Insurance Act, and this was enacted in 1997, by the way, and you don't have to remember the year. The key federal employment statutes, and once again, we're dealing with human resources. So the Labor Code of Canada, and in addition to that one, the Human Rights Act in Canada. Now, this is synonymous throughout all provinces. No province can modify this. Remember, it's the higher authority that always comes across. PAPEDIA, which is federally operated. And this is the protection of all the people in Canada, not just in a particular jurisdiction. The Canadian Pension Plan, which is federal. And that means when you actually retire, they'll send you $1 or $2, only after they've taxed it. The Employment Insurance Act is federal. It's not provincial. And therefore, the funding given to each province is ever so slightly different. So those are the statutes that are actually quite significant. However, now you come back to the idea of what is accepted by all people. So this is common law. And in common law, it's developed over hundreds and hundreds of years, literally hundreds of years. And it's whatever is to the advantage of society as a whole. So things do change as societies change and the perspective and let's say the character, the demeanor, the behavior of people, as it changes, so does the law. The law is not inflexible. It does actually have some degree of flexibility. This is a term you're going to need for your final exam as well, start decisis. And this is, it is fundamentally the same thing as you're on your own to stand by things decided. So standing by things decided is Latin, and it just simply means to stand by things that have already been decided. So once again, a lawsuit that took place 100 years ago with an outcome that is exactly what yours should be, you'll have the same kind of judgment given to you. Doctrine of precedence is a very important concept. The court must follow a ruling already issued in a case involving similar situations. So what we're really doing here is redefining common law. It's the same thing over and over again. When something has been accepted by society as a whole, then it is the same ruling that is given over and over again for the same situation. Now, if the situation is variable, it has the same elements, but it may have some other elements associated with it, then of course there may be two elements put together, but it's going to be the same two elements that have come over a period of time. The whole idea is to make it even-handed because as I gave you the story of the king, what actually was taking place was a major uprising. And there were a lot of issues taking place during that period of time. There was a lot of corruption and people didn't treat people very well. So people were uprising and wanting to fight and go to the king and kill the king, so to speak. And of course, by creating the roaming judges, he kind of eliminated the problem to a degree. But some of the roaming judges were just as corrupt as some of the sheriffs. So he eventually found that with people who were happy, those same cases seemed to work really well in the hamlets where people were upset. So this is where that philosophy of precedence comes from. If it worked for one group, it'll work for another group. And that's what common law really is all about. The decisions of the higher courts are binding in every situation. So if a lower court in, let's say, a town, you're not too happy with it, you can appeal it to a higher court. If the higher court has a different decision, then you take the higher court, whatever the decision is of the higher court. So a lower court might have given you some money. A higher court might have said, no, you're not getting it, so you don't get it. So branches of common law, there are parts of it that are different. And these are parts that you and I really need to know a little bit about. Contract law is a big one. This is a very significant area of common law because virtually everything is taking place based on the assumption of acceptance of whatever is said or done. And there are three different kinds of a contract. There is the written form, the verbal form, and the intended form. There are three different elements to it. So in the legal course, we'll really rip it down because there are quite a few chapters on it. Tort law is an interesting area of common law as well, and it really is important for us as well because it deals with a wrongful act. A tort is anything that could be harmful or disadvantaging from one person to another. So let's just say that somebody went to your office and they put something in front of the door and you couldn't open the door. That's a wrongful act. If somebody prevented you from going through a door, but you had the right to go through that door, that's a wrongful act. That's an offense in a sense, and you can sue for that. A tort is a wrongful act. A contract is an agreement between two individuals or more. So contracts determine whether an employer and an employee have a relationship. And remember, it's an agreement between two sources or two, let's say, entities. Each entity agreeing that the violation of the contract or avoiding of the contract is not possible without consent of both parties. And therefore, there are legal consequences for non-compliance. That's the most important element of a contract, is that there is a legal consequence if one party does not live up to what the other party has agreed to. In order to end the relationship, be very mindful. Contracts do not terminate without an agreeability factor built into it. It must have inside the contract how it is terminated or how it is voided or how it is closed. If that doesn't exist, it theoretically cannot be closed. This is like a marriage contract. If you didn't have an agreement that there could be a nulling of it or there could be some other kind of condition, then you wouldn't be able to break the contract. It would exist forever. So it must have a just cause to end the relationship. There must be a clause inside of it that defines it. When a contract is breached, the damages can be sought by the plaintiff. So let's just say that you were not happy because the company did not pay you what they owed you. Well, then you could sue them because they violated the contract. Remember, the contract will stipulate both parties' responsibilities. And there can be no such thing as a one-sided contract. In other words, one person created it for themselves and everybody has to agree to it. It doesn't work that way. It must be a two-way street. You must both agree to it. So this is where the employer and the employee come to terms. And it is documented and you both get a copy of it and neither party can violate it. So contracts have legal consequences, so do torts, because a tort can exist by making a danger to the workplace. It can exist because of a wrongful act of some kind or another. So wrongs and damages that one person or a company can cause to another. And again, it could be that maybe the company made it dangerous inside the work area that you're working in. That's a wrongful act. Maybe they stole something from you. That's a wrongful act. So anything that would be considered an act that is incorrect or wrong, fundamentally wrong. Damage and wrongs can be intentional or unintentional. So let me give you an idea of an unintentional. Let's just say that your neighbor has a swimming pool and it's now fall and they want to empty it so that they don't end up with an ice block. So they decide to empty it, but it also swamps your property because you're a little bit downgrade from them. And the second problem is it finds its way into your basement and, of course, does a lot of damage because of the water. Well, that's a wrongful act, but it's an unintended one. They didn't intend it, but they are still fully legally responsible for the damages. So this is a very interesting conundrum. I can give you a really interesting example. This happened 25, 30 years ago. This happened in Brampton. In Brampton, in the, just trying to remember the name of the area. It's the northern section of the area. Anyhow, in the northern section, as they were building more and more houses, and this is about 30 years ago, they were expanding north into the regular farming community. And as they were doing that, many of the farmers were actually putting sheep manure down. Now, I don't know if you know the difference between sheep manure and cow manure as an excellent way of making your crops a little bit healthier. But sheep manure stinks really bad. I mean, it's really bad. Well, many of the people who had just moved into those new houses, they decided to sue the farmers because they said it wasn't fair. They couldn't go outside the house and breathe normally. You had to hold your nose because of all the stench. It only happens for maybe a week, and then after it rains a little bit, it disappears. But the people were successful. They were able to successfully sue the farmers, and but the courts didn't give them any money. It just told the farmers plow it a little bit and try to remove the smell, because you recognize the farmers have a right to try to produce food for you as well. But that's also unintentional. The farmers never intended to disrupt your ability to enjoy walking out of your house and being able to smell clean air. In this case, it wasn't so clean. So there is a big difference between you intended to damage somebody else, or you unintentionally decided to do something. For intentional, I'll give you a really good example. In the United States, they have similar rules. They're not exactly the same, but somebody decided one day they owned a restaurant, a drive-through, beside another drive-through, and they decided to park their truck right in the drive-through of their competitor, and then lock it and chain it so that nobody could actually move it, which meant that all the people going to the competitor would not be able to, and it would have to come to his place. That is intentional, and that's a deliberate act. And it's, in addition to a tort, it's also a criminal act. So in that case, there were two different rules applied. One, criminal intention to defraud and to steal from the other company, and of course, a wrongful act deliberately trying to harm the other business. Damages can be independent of any contractual relationship. I have to get some new glasses. So hopefully that makes a little bit of sense between contracts and also with a tort. We'll be coming back to that in the legal course, and we'll go a lot deeper into it. Judicial framework. So this area here as well, each province and territory has a provincial court. They also have a superior court system, and that court can hear cases involving either federal or provincial law. And again, remember, federal will always come first, provincial second. Each province has a superior court, which have special divisions, and this could be family division, but part of the superior court is also a small claims court, and that's part of the superior side of it. Each province has a court of appeal. This is called the appellate system, and appeals can be heard again at the same level, or they can be escalated to a higher level. So appeals of rulings made by a superior court and provincial courts, if you are not satisfied and maybe certain information was not permitted to be brought forward, all the TV programs you watch where they run in at the last minute and they have new evidence, that's kind of baloney. It doesn't happen that way very often. Maybe 1% may happen that way, but it's extremely rare. And the reason is because our legal system is based on providing information in advance. So it's called disclosure. And if you wanted to go to court, it would take you years to go through court. So our system is designed so that both sides can acquire the information that the other side intends to bring forward. They don't know how you're going to bring it forward or what questions you'll ask, but they know what the evidence is you intend to bring. And that makes it easier, and it condenses the amount of time that the court will have to sit. Again, every day could cost you thousands of dollars, so you definitely want to make sure it's a speedy process. Supreme Court of Canada is the highest level in Canada. There is only one court that is higher than this, and that's the International Court. And unfortunately, they only listen to issues on a, let's say, a national level. There has to be a serious problem within a country for somebody to sue another country. Right now, I'm surprised people are not suing China, but that's something that we may see coming up. So this gives you an idea of the system. This is important to you, believe it or not. There are two sides of the legal system. The first one is, as you notice here, the Court Martial Appeal Court. This is military only. What we're impressed with is what is in the middle, because the rest of it is kind of like aside from what we're really looking at. Here, provincial, territorial courts, the Court of Appeal will always be the last court before you get to the Supreme Court. Provincial, territory, and superior courts, and again, from that, we have a variety of different issues, family court, and a variety of other ones, including small claims. And then, of course, just the regular provincial courts as well. The far right-hand side is an interesting area because when we try to go to the higher court, federal courts, then you go through the same philosophy. There's a federal administration tribunal. These are not courts. They're actually separate. They're like Department of Transport or Department of Fisheries. The administrative branches use tribunals. And these are usually people who work within that organization who have been licensed to sit and listen to cases that are brought forward, especially for departments of government. Federal court on the federal level, and then an appeals court. And the one court you must always be very, very careful with, and that's the one on the far right-hand side. This is the tax court. Revenue Canada. I'm only going to say one thing, and I only know this because a friend of mine ran into this. If you ever have an issue with Revenue Canada, solve it immediately and then fight. Do not fight first. Pay the fee, whatever it is, and then fight them. Because Revenue Canada is a federal institution with incredible power. And it has the ability to not only provide interest, but penalties on interest and penalties on principal, penalties on owings. It's a very nasty court. It has tremendous power, but it's better to fight them first and then, pay them first and then fight them. That's the idea. So anyhow, just be aware of how this is actually broken down. Judicial framework. So not every court in the country can deal with every subject. Judges are very well versed in one particular area, and that is jurisdictional law. So they are very cognizant of the rules that apply in their particular genre, whatever that happens to be, whatever field that they're particularly a part of. If it happens to be the Highway Safety Act, that's all they know. If it happens to be constitutional law, that's all they know. If it happens to be municipal rules, that's all they know. It also means that there's a lack of judges and a lack of courts available. So the government originally broke it down so that government agencies would actually be administrative, and therefore they would have their own tribunals. You can fight a tribunal. If a tribunal does not agree with the outcome you would like, it is possible to go to court, but a court justice can only send you back and correct the situation, and then you have to retry it again through an administrative tribunal. It's a different philosophy, but there's one advantage here with administrative tribunals. There's a lot of gray areas. Where in a court, it has to be black or white. It's either fact or it's not fact. And in a tribunal, it can be a gradient. It can be a little bit guilty or a lot guilty. It's not a question of being one or the other. You're either innocent or you're guilty. It's somewhere in between as well. So there's a lot of latitude as far as administrative tribunals. Established to make decisions in specific areas, and they're only giving you two examples here, but transportation is one. There's a lot of different areas, bringing product into the country, whatever it happens to be. So agriculture or environment, or it could be employment or education, it could be anything. But literally there is a tribunal for that particular agency that will listen to your case. And it's not normally one person, it's usually several different people. Administrative agencies as well, empowered to investigate complaints. Usually this is complaint driven. So this is not something they go looking for problems. You have to advise them. So administrative agencies, and again, this is connected with the tribunals, empowered by investigate complaints, make rulings, and sometimes orders. And they do in some situations, depending on what particular organization it is to apply very significant fines as well. Piece of cake. Was that easy or what? So any questions about that chapter? I know we kind of went through it rather quickly as well. Uh-oh, anybody still there? Or are you sleeping? Uh-oh, they're sleeping. No questions for Desiree. Fantastic. Yes. Yes, sir. What does that? You're back? I'm here. Okay. You lost your mic? Fantastic. Okay, so let's take a look at chapter number 10 then. Just keep in mind, chapter number 9 does come up. It doesn't come up very frequently on the final in a big way, but it does come up. And there are definite areas that you want to remember. Administrative law, dealing with common law or statute law, precedents. These are elements that really do kind of come up every so often. But this chapter number 10 does come up big time. And the reason it comes up is fundamentally for one reason. We're dealing with human resources. And therefore, human rights code absolutely is something that needs to be understood in human resources. So there are conditions when we want to remove somebody or we want to discipline them. And it's important that you understand what the conditions and requirements are and the responsibilities. So let's take a look at the grounds for dismissal. This is number 1. Every citizen in Ontario has the right not to be subjected to discrimination. Discrimination cannot be used as a result. So, or any of the following, and you must know the 17. So, bad news, guys, you have to memorize these. So, there's 17 actual codes, and you need to know each one of them. Now, you only need to know the name of them. You don't really have to know a lot about them, but knowing the name is very important. So discrimination is something you cannot apply. Citizenship cannot discriminate against, let's say, citizenship except when it is requirement to have Canadian citizenship for a job. There are jobs simply because of 9/11. When 9/11 took place, a lot of changes took place in national security in Canada and the United States and many countries in the world. One of the conditions was to work at specific places that were federally controlled. You had to be a citizen or you had to prove national security's interest that you were capable of taking on those positions and that there were no security issues. You cannot hold a person responsible for, let's say, the race that they're from. So no discrimination in that particular area. The place of origin doesn't matter where you're coming from. Ethnic origin doesn't matter what the ethnic origin is. And the color of skin makes absolutely no difference whatsoever. We all bleed the same color. Ancestry doesn't matter what your ancestry is. In some countries, these are important issues. China right now, these are really something you definitely want to be careful of. But in our situation, age is not something, and there's a big change here that took place not long ago. The right to be free from any form of discrimination on the basis of age. If you are at least 18 years of age, mandatory retirement at 65 is gone. History, bye-bye. Senior discounts are acceptable. What happened in the area of age was a lot of older people started to look at politicians and started to look at judges, which do not have to retire until they're 90 years of age. Well, people were saying, wait a minute now, at 65, I have to retire, but you can go on until you're 90. Doesn't really make sense. So the government changed it. There is no requirement for an actual termination of retirement. Nowadays, you can retire at any age you want to. However, your pension starts at 70, whether you like it or not. It just starts. Disability is another area of discrimination. This is something you're not permitted to do. So this number 8, broad definition of disability is not clearly defined. It is not defined. And this is something that for those people who go into human resources, it is a very significant challenge. Therefore, a disability includes the obvious and not so obvious. And this is why it's not clearly recognizable. It may require some consideration on both parts. There is a requirement to accommodate. So even if it's a minor situation, you would still have to accommodate. A disability, an individual who has migraine headaches, for instance, is a disability. An individual who's an alcoholic has a disability. Even though you wouldn't consider it a disability, it is a disability. The creed or religious faith, you cannot discriminate about creed as well. Sex or pregnancy, if an individual is pregnant, or the sex of that individual, male or female, or they have a preference for one or the other, it's none of your business, and therefore that also is an area you cannot discriminate against. Family status, including biological and adoptive parents. Again, it's just a question of history. Sometimes people had multiple different connections and people discriminated against them. Just to give you a quick example of how that comes in, when many people came from Ireland to North America, especially the United States, they ran into problems because the Irish were not considered to be at the same level as the British. So family status was an area for discrimination. This is one of the reasons it's not allowed anymore. So discrimination against family status is not permitted. Marital status as well, being married or not married is irrelevant. It has nothing to do with anything, and you can't discriminate against it. And of course, number 13, sexual orientation. Once again, I just mentioned this. This fits in with a different group of people. Human sexuality, lesbian, gay, bisexual, heterosexual. This is well defined within the code in Ontario. You cannot discriminate in that area. Gender identity, each person's internal and let's say individual experience of gender. Again, there are individuals who are slightly different in their perspective, and you cannot discriminate against them as well. 15, gender expression, how a person publicly presents their gender. Again, this is the way they actually represent themselves, their voice, their language, pattern within what they say. All of these things, you cannot discriminate against it. I think the most important element is we remind ourselves that we're really hiring skill sets, the skills necessary to fulfill the obligations the company is trying to satisfy for the customer. We're not really hiring an individual per se who dresses a certain way. We're doing something a little different. We're trying to hire the skill set. Record of offenses is an area that can actually have exceptions. Record of offenses, employer must look at a person's record of offenses and also consider whether the offense would have a real effect on the person's ability to do the job and the risk associated with the hiring of that individual. In other words, doing that particular function. This is the only area that there may be a little bit of gray area. And again, the rationality is if you're having somebody at, let's say, a cash register and they have a history of stealing, that may not be a good idea. So you might want to choose differently. And number 17, receipt of public assistance. If an individual is on, let's say, public assistance programs or social assistance, you cannot actually discriminate against them. Some people do. They assume that maybe the individual is not intelligent. That's not true. It's just a perception. And therefore, it's better that we have a rule that stipulates you cannot discriminate. So there are 17 of them, and you definitely want to take the time to make sure you go over each and every one of those very carefully. So to establish discrimination under the code, a claimant must show, and again, it's really a question of, it's a complaint-driven system. They have a characteristic protected by the code. That's number one. They experienced adverse treatment within a social area. That's number two. The protected characteristic was a factor in the adverse treatment. Let me just go back to those for a moment. So these are three, and as I said, it's a complaint-driven system. So yes, the government is more than willing to listen. So if you want to levy a complaint, you have to prove that this is the situation. Now, the bad part of this is it's not an easy thing to prove, because if an individual decides not to hire you because you're a gay or lesbian or transsexual or whatever it happens to be, there's no way of proving it. You would literally have to have something in writing, or you'd have to have videotaped it, which unfortunately also means that you have to have their permission to videotape or to audio tape anything that they have to say. So if you can do that, great. If you can't, well, unfortunately, you're going to have a real uphill battle. So this is a disadvantage, but it also makes sure that you're always innocent until proven guilty, and that goes for a company as well. Additional grounds of discrimination. You cannot be denied a position because of an associate with a person of a certain religious belief. There is a caveat here, and I'm really not sure how it works out because I'm just not into that field. But for certain religious groups, they only hire people of that particular religion. That may actually be what is referred to as a bona fide occupational requirement. I'm not sure. But in most situations, and I would say probably almost all of them, you cannot discriminate about an individual having a connection to somebody of an alternative religion or alternative belief structure. It does not cover political association, okay, whatever. Discrimination through reprisal. This is something you cannot do either. And employers cannot discriminate against someone for asserting his or her rights, for refusing to discriminate against another person. It happens. Sometimes you get people trying to gang up on someone, either to remove them from the company or not to hire them or whatever it happens to be. You cannot coerce other people. So in this case here, you cannot discriminate against someone who has refused to play your game in a sense. And direct discrimination and indirect. So direct discrimination means discriminating against someone because you think they're different from you. That's, we're really lucky we have a big wall between us and the United States because they really have problems with discrimination. Again, it's one of those things, direct discrimination, because you see the person as being different, get over it. You cannot discriminate against them. So if direct discrimination is a direct approach, then indirect discrimination is a roundabout approach. Happens when certain demands of a rule seem to be fair, but actually exclude some people under the grounds listed in the code. There may be situations where something just doesn't apply. You'll find these every so often. Also known as constructive or adverse effect discrimination. So just remember the terms associated with it. Employer has a rule that all men must be clean shaven. Well, that kind of discriminates against those practices such as they have here, the Sikh religion, which requires that men grow a beard. There are other religions who also, Islamic, again, growing a beard. This also goes for a variety of different things, from wearing the headgear that they also wear as well. You cannot discriminate against that. If an individual has, for instance, religious beliefs where they carry, I think this actually happened in Mississauga first. In Mississauga, there were some children who went to a public school and they were part of the Sikh or Jain group, and they carry a ceremonial dagger, and it's only for ceremonial purposes. However, the kids were carrying a dagger into classroom, and in Ontario, you cannot have a weapon. So carrying a knife of any kind was a no-no. However, it also is a discriminatory factor because it's indirect discrimination against the religion. So the children were given permission to carry the dagger, but the daggers had to be sheathed and you could not pull it out. So this is something that they had to figure out somehow to solve that issue. There's also another area, so direct, indirect, and systemic discrimination may be part of a system. such as how decisions are made within your particular organization and the practices and policies of a culture of the organization. One of the things that often happens is a lot of people don't like some of the North American kinds of events that take place. Halloween, for instance, Christmas, for instance. There's a few different ones. If they've come from specific countries, they may not agree with those particular types of events or holidays. So this also is called systemic, whereas maybe the company decides to shut down at Christmas, but not shut down on, let's say, one of the other holidays for another religious group. Well, if that's the case, then unfortunately, this is systemic discrimination and they need to change the name of it. 5 areas of social activity covered by the code. So once again, so these things you have to remember, 5 areas. Codes provide that everyone has the right to be free of discrimination. No one in your company should be discriminated in any way, shape, or form. It also means that managers and supervisors have to be very proactive, ensuring that no one is isolated or called out in a sense in a discriminatory way. So following the 5 areas of social activity, so let's take a look. Services, goods and facilities, housing, also vocation, associations, and also unions. You cannot discriminate in these areas. And contracts. Contracts must be very specific and legal in nature. This is another area where if there are any issues, it can be taken to a court. Court will not change the contract. The court will actually make you change it. And employment. So these are the 5 areas. These are the 5 codes. This particular area is social activities that the government covers and the companies are required is services, goods, and facilities. We'll take a look at these as well. So you have the right to be free from discrimination when you receive goods and services or use facilities. You cannot be discriminated upon. In some places in the world, there are, let's say, washroom facilities for certain people and not for others. There are doors for one particular group and doors for another particular group. There are areas for one group and not for another group. I know that in some countries, women are in one section, men are in another section, and they are not permitted under any circumstances to come into contact with one another. This is just a kind of discrimination. But in Canada, you, within an organization, you must be free from these peculiarities. Stores and restaurants and bars, this is another particular area. You cannot be told that you can't participate or you can't use the store. Hospitals, health services, everybody is covered the same way. Public places, no one is excluded from the use of. Schools and universities, anyone, doesn't matter how old you are, is entitled to any kind of education in Canada. That's a nice feature, by the way. The services, goods and facilities, again, provided by insurance companies, exemptions when pre-existing conditions increase the risk. There is an exception in that particular area simply because maybe what you're doing is going to cause a problem. Must be 18 to file a complaint. Once again, you should be 18 to have a particular job, and therefore that's the age of consent when you can actually vote as well. So parents do so on behalf of anyone under 18. If you are currently under 18, you're considered to be an infant. Under the Canadian legal system, You cannot enter into a contract, and yet many do. Rights to education, community, and other services that respect your religion and your beliefs. You cannot be harassed and you cannot be prohibited from participating. When it comes to housing, every person has the right to be free from discrimination in housing and also the right to equal treatment when buying, selling, renting, or being evicted from a house. There are laws and there are rules that actually specify how this has to go about. And sometimes people get a little hot-headed and they don't follow the rules, which usually means they get sued. Landlords cannot discriminate on age. So, on any of the 17 grounds, I was just going to say age as well, on any of the 17 grounds. So any of those 17 grounds, they cannot say no. If you brought a dog in, they could say no. But if it's any of the 17 grounds, no. Cannot refuse to rent to someone based on religion or sexual orientation. So there are some conditions that go along with the acquisition of a house, and it really has a lot to do with whether or not you can even afford it. So even though they can't prevent you from participating, excuse me, the filtering process would be based on, can you even afford it? So if you don't have any money, yes, they can say no. If you have no way of actually acquiring any money, they can say no, because you wouldn't be able to live up to the expectation of a contract. Vocational associations and unions. This is an important area as well. Everyone has the right to join and be treated equally within a union or an association, and there are many different professional associations. And again, you can't deny somebody the opportunity to participate simply because they're part of a union. So let's just say that your company has a health and safety committee. If somebody in the union said, I'd like to participate in that particular group, you couldn't actually say no because they're in the union. Because they're an employee, they have a right to participate if there is a spot available. Professional associations, the same thing. Somebody wants to participate within them and is from one of them, you have to give them the opportunity if the opportunity exists. Landlords allowed to screen the tenants. And again, it really is a question of, do they even have the ability? Sometimes you find that people want a particular residence, but they just don't have the money for it. Rather than get them in there and then have to fight with them for month after month to pay their bills and they won't do it, it's easier for the landlord to just simply say no. But when it's a 17 grounds, they cannot say no. But money is not one of those 17. Allowed to discriminate in same-sex residences, no boys in all girls accommodations. There's a rationality behind this. This has to do with schooling and universities, especially colleges, universities, where there may be a Pratt house, or let's say a house that is deemed for the purposes of the students. It may also fit into certain kinds of apartment complex as well, where you may end up with a situation where all of the residents are female and therefore males are not permitted within, and it's a security issue for them as well. But on universities especially, those houses that are used for the students are fundamentally 100% female or 100% boy, male, or it could actually be a combination of the two. But in many cases, it's one or the other. That's where the rule came from. Transgender, I should say, transgender, should be accommodated according to lived gender identity. So once again, the individual wants to be male at that time or female at that time. You cannot discriminate with that individual. And if that's the way they want to live, they are entitled to their own self-expression. Adult-only housing not allowed. Discrimination against your family status. This is an area which I have a little bit of issue with. There are a lot of senior citizens who will get together. Their kids have already left the house. They sell their house. They want to move into an apartment somewhere, but they want a building where there are not a lot of kids running around, pulling the fire alarms and, screaming up and down the hallways. And unfortunately, that's not permitted. So you cannot discriminate against your family and what's available within your family, such as kids or husband, wife, what have you. So one of the areas that is really important in law, period, is contract law. We've also talked about torts, the wrongful act, but contracts are I guess you could call it the king in a sense when it comes to legal binding agreements. So contracts, in this case here, every person has a right to a contract on equal terms without discrimination. Again, it's really important that a contract be homogeneous so that it applies to everyone who's doing the same thing. And there are no quirks within it because you happen to be taller, shorter, or faster or slower, whatever it happens to be. There is no discrimination, period. And the contracts cannot be designed so that they are discriminatory. Covers all steps in the contract, and this is really every step. Contracts are really well defined. They should incorporate virtually every situation that you could run into. Offer, acceptance, price, and even rejection. If you decide to reject the contract, what do you do? Offer. If the contract is presented to you, you do not have to accept it. Or yes, if there is a way of accepting, how? That's a very important issue. I'll give you a quick little story. So it'll kind of give you an understanding of why it's so important for that condition to be in there, especially acceptance. This goes back to about, well, I guess 50 or 75 years ago in England. We do follow the English system because that's where the law actually was imported from, in a sense. In England, somebody was selling a cottage, which is like a house in the country. And a person from London had gone out on the train and saw the little cottage, really liked it, and decided to buy it. And he said, I will respond to you today. And the owner of the property said, okay, let me know. And you have to let me know before midnight. So he went back to London, and by the time he got in, it was quite late. So he went to the post office, which is a little different in England. He went to the post office and he sent him a letter of acceptance. Now, unfortunately, the post office in England is just like the one in Canada. It's very slow sometimes, and it was several months before the response was actually received. And the man had already sold the property to someone else. So this is what happens when you have a contract. As I said, there are three kinds. There is the written, the verbal, and the intended. So in this situation, the man in London took the owner, the previous owner, to court and sued him for the cottage, which he would have to pay for. The justice agreed that he had already agreed, and he agreed. But when the owner of the property said, wait a minute now, I received a letter a month later or 2 months later, whichever it was, and it said, yes, I've accepted, but I had already sold it. And he said, yes, but you didn't tell him how to accept it. So anyway, any method is acceptable. And because the letter is stamped by the Crown, in other words, the government, the post office is a government agency, because they had stamped it with the date that they received the letter, and it was the same day that you had verbally agreed that it should be before midnight, and the stamp is before midnight. Everything had to be reversed. So the people who had moved into the cottage had to move out, had to sue the original owner to get their money back. And of course, the owner lost the cottage to the person in London, who then only had to pay him what he had originally agreed to. So this is why contracts have to be very specific, because when they're not, people assume that it's one of three different ways, and it can be difficult to prove. Now, if they had just said it was by verbal, then it wouldn't have worked, except for one thing. When the judge asked the original owner of the cottage, he said it had to be by midnight. And when the judge looked at the letter, he noticed that the post office had stamped the stamp, which had a date and a time on it, and it was before midnight. So this is a written type agreement where it actually was driven from verbal and also based on intention. So auto manufacturers cannot refuse to enter into a contract with an owner of a dealership because the owner is gay. Maybe during the 1940s and 30s and 50s, but nowadays, no, you can't. It's just discrimination, pure discrimination. In point number 5, employment, everyone has the right to equal treatment during employment. And again, this is where you have to have policies, because managers sometimes they make up their own mind as to how to deal with somebody. You want to make sure that everyone in that company is being dealt with exactly the same way. And usually human resources will set the policies for the company. So when applying for a job, the training, the transferring, the promotion, and any form of layoff is predefined so that everyone knows the responsibilities. People with disabilities have the right to be provided with equipment and service to assist them in their job. If an individual has a need and has some kind of physical disability or some other form of disability, it's up to the company to accommodate, to try very difficultly sometimes and financially to accommodate for that individual. This may mean putting a ramp in, it may mean putting an elevator in, it could mean a variety of different things, just simply moving them to a floor that they can access, computers that they can actually work with, tools that they need, whatever it happens to be, special chairs. There are many different types of disability, and therefore they need to be able to accommodate. Employer must respect sincerely, help beliefs and also practices. And employers must avoid unintentionally screening out certain job candidates because they may have a disability, or maybe there is something they don't like about them. Maybe they're not wearing the right clothes at the right time. There are all kinds of minor little prejudices. Maybe their eyes are brown instead of blue, or green or brown or some other color. Who knows? Maybe they have turquoise eyes. Maybe they have two eyes that are different. That's interesting. Green and blue or green and brown. Interesting combinations. Or it could be something else entirely. Maybe they walk with a limp. Maybe they have a beard. Maybe they have something, whatever it happens to be. There are exceptions to every rule, and sometimes they're valid exceptions. I remember when I was a kid, some family person we knew applied for the police department, but they were too short. And they couldn't actually become a police officer because the requirement that time when I was a kid was you had to be 6 feet tall and you had to be able to run really fast. And they would check to see how fast you could run. I got to keep in mind times were very different as well. And therefore, some of the conditions were different. They had to catch me, especially after curfew. When kids, by the way, used to be, you had to be in the house by 9 o'clock. And if you weren't in at 9 o'clock, the police had the right to pick you up, drive you over to your house, and tell your parent on you. They had a lot of times with me running around at night. So BFOQ, in this case here, bona fide occupational qualification. You can't hire somebody who needs to be a truck driver unless they have a truck license. You can't hire a forklift driver unless they have a forklift driver's license. You can't hire a real estate agent unless they have a real estate license in Ontario. So there may be a qualified reason. You can't hire somebody to do gas fitting, let's say for gas lines or something like that, unless they have the licensing required in Ontario. So there has to be some conditions here. Must pass the three-part test, and this is an important element, and this is based on the Supreme Court of Canada's decision. Adopted for a purpose rationally connected to the job performance. If somebody has to lift heavy weights, then somebody who cannot even lift them, that would actually be an exclusion. I could discriminate against that individual. If their job was to lift heavy weights all the time and they weren't even capable of lifting the weights, then of course that would be a good reason. If their job was to type and they were incapable of typing, then that would also be an acceptable reason not to hire that individual. So once again, what they're saying here is it has to fit the need that the company is looking for. Adopted in an honest belief that it was necessary to, let's say, satisfy a legitimate business purpose. And again, it could be that whatever it happens to be is necessary for that particular organization. It could be that you must have transportation. If you don't have transportation, they can't hire you. Again, that would be an honest belief that if you didn't have transportation, you wouldn't be able to do that particular job. And the third reason must be reliably necessary to, reliably, I need new glasses, reasonably necessary to accomplish that particular purpose. So you really do have to have some necessity to be able to, or some skill set to do that particular job, whatever it is. These are the three requirements. Adopted for the purpose, also honest belief that you need to do this or need to have this in order to accomplish it, and also reasonably necessary to accomplish the purpose. Maybe you're not even capable of sales, and yet it's a sales position. Maybe you cannot use a computer, and therefore that's one of the requirements of the job. So there are three fundamental conditions the Supreme Court has come up with as absolutes in a sense. There are exceptions, as I said. So bona fide is one. The exceptions where discrimination is permitted. And there are very discrete areas. So discrimination is allowed to in the following circumstances: special service organizations, bona fide occupational qualifications where you just don't have the capability to begin with, nepotism, in other words, the hiring of family, medical or personal attendance may not be feasible because of your medical conditions. Special programs that you may be in that they are incapable of participating in. So special service, let's take a look. Equal treatment not infringed on for special service organizations like religion or fraternal organizations. Faith-based organizations can stipulate the counselors must be of the same religious beliefs or the same relevant faith. For faith-based organizations, taking government funds this may not apply. Again, it really depends on how this is structured. The bona fide, once again, an employer may discriminate on the basis of age, sex, record of offense, or marital status if these are genuine requirements of the job. Now, there may be very specific reasons for these. Sex, for instance, could actually be that maybe a man demonstrating or being a model demonstrating women's clothing may not be the most appropriate use. Women, the same thing. It might be vice versa. It could be a variety of different things. Record of offenses, once again, there may be a reason why this would not apply. You cannot get into the fire department or the police department with background, unless, of course, it's a very simplistic one. Male attendant in a locker room. Again, I can give you a really good example of this, that this did come up in a university. There was a job offer, and this was for a frat house where it was all women. And it's, you got to keep in mind, these are young women, anywhere from 17, 18 years of age up to maybe 8, 19, somewhere in that area. And there's maybe 50 to 100 women living in that particular house. These buildings are big. So they were looking for someone who would take care of it. They call it the mother of the community. In this case here, they put the ad out, and it was a man who actually applied for the job. Nobody else seemed to be interested. And they only had one applicant, and he happened to be male. The problem is, the girls and their parents did not appreciate this at all. They didn't want a man in there while girls are getting changed in their house or wandering around, waking them up, for school and stuff like that. So he actually took it to court because he was denied the opportunity. And when it went to court, it actually was rather interesting because the court said he had to be hired, because he had the qualifications. He had something like 8 sisters, and he was the oldest child, and he had actually brought them all up because the parents were never at home. So he was always taking care of his sisters, teaching them, helping them, dressing them, what have you, buying clothes for them, whatever it happened to be. So he was genuinely skilled in that particular area. What the university eventually had to do was give him a job in another department entirely, because the parents of the children, the girls, refused to allow it. But it kind of gives you an indication that sometimes bona fide can backfire a little bit too. In his case, it did. Nepotism, an employer may choose to hire or not hire. Again, it really depends on what it happens to be. Maybe it's their family that they're promoting through the company. So promote or non-promote. Again, the spouse, it could be the children, or it could be a parent. You're hiring these people or you're not hiring them. And you have that right. This is called nepotism. And this goes above and beyond anyone else who would be looking for a job out there. An employer may give preference for student employment to the children of the employees, which often happens. Many companies provide the opportunity for their employees, for their children who are, let's say, in the middle of summer, to have a summer job or something like that. And you can discriminate against spouses, children, or parents of the employees if they are not what is closely related parties working in the same area. So sometimes you may not want them to be working together. There's a problem that can exist with families working together. Husband and wife working at the same company is sometimes not a good thing, simply because if they get into fights, they both usually take the same time off, or their work diminishes rather significantly until they make up. And everybody in the company knows what's going on. So some companies avoid this by simply saying they will not hire both. one or the other. The next area is medical. So medical or personal attendance. This is another very important area. In the situation of home care of an ill relative, per se, that relative has the right to decide who can and who cannot be there. This is one of those unfortunate things. I had an aunt who had cancer, and she was ill for quite a while. It was very important that she have somebody she liked because she was quite ornery as well, a tough person, smart, very tough. And you had to have the right person. Otherwise, it would just be arguing and fighting all the time. So that individual has the right to choose. A person may refuse to employ an individual using any of the 17. Once again, if an individual is sick, they have a right to be attended by someone that they prefer. Again, this is a very important element, especially, let's say, before death or something of that nature. They have rights, and you have to live with that. As long as the primary duty of job is attended to, the medical or personal need of the relative who is ill, senior care in a home or what have you, again, there are conditions that are applied here. And this only applies when a person is ill and asked to reflect the person's nature of care. So in other words, it's not really the person per se, but I got news for you. It's the person. When a person is ill, they basically know who they want to talk to. And I think in many cases when people are ill, it's really a question of talking to them than anything else. It does not apply to nannies of healthy children, but to sick children, yes, it does. So that brings us to special programs. Again, these programs may actually be defined. Let's say an individual has certain conditions that don't allow them to perform at the same level someone else does. So they're taking special programs to assist them. I've run into people like this in the past. They require opportunities just like anyone else. And it's really a question of you cannot actually discriminate against them. But there may be conditions that make it impossible to do anything other than. So in special programs can be designed to promote the status of disadvantaged groups. Employer can prefer to promote people who typically suffer from employment discrimination. This is quite possible. Excuse me. Allowed to discriminate against others on grounds that they're prohibited. There can actually be a variety of reasons why you might do what you're doing, especially for special needs individuals, and often known as affirmative action. In this case here, we're providing them with an opportunity because it's the way the company has a policy. If you look at Walmart, Walmart actually has a very significant program in this area where they will hire individuals who are slightly disadvantaged in one form or another. And with number 5, harassment, employer has the duty to provide a working environment that is free from harassment and discrimination. This is such an important area. This must be performed by supervisors, managers, and as I pointed out at the beginning of today, it really is a proactive statement. It's something that you cannot hold back on. If a supervisor or even a manager of any form actually notices that there is any harassment of employees, they must interact immediately. And if they notice discrimination, they must act immediately. This is really important. And also that these events are somewhat documented in some way so that they don't reoccur And of course, the rest of the staff need to know this is inappropriate behavior. It's so important because they can go to the labor board and levy a complaint. And then, of course, it becomes a bit of a nightmare for the company. So supervisors and employers are really legally responsible for making sure that that environment is safe. And that's for everyone in that organization. And by the way, harassment comes in oh so many different ways. Before I go to the next little line here, I'm going to give you one that went all the way to the Supreme Court. And it had to do with a woman who liked to use all kinds of cologne. And she used it as if she bathed in it, because as soon as she'd get off the elevator, complaints would immediately start rolling out from all the people on that floor. It would be just like a wave of scent that would come across. So eventually, after months, they actually had the woman, the supervisors told her that if she didn't actually come in without scent, in other words, don't put cologne or perfume or anything on, then they'd have to release her. They had no choice. This actually ended up going all the way to the Supreme Court. And it was the woman who actually took it that far. And the Supreme Court agreed with the woman. It's her right to wear perfume if she wants to. But they also agreed with the company. It is up to the company to ensure it's free of harassment and discrimination. And therefore, because this woman represented harassment to all the other employees on the floor, and basically, if they had agreed to allow this, it would have been discrimination. In this case here, she was terminated from her job. Simply, she would not receive anything. And the reason, once again, was she was affecting all the other staff members, and that was a form of harassment. So harassment is defined as engaging in a course of action or vexation and or conduct that is known or ought reasonably to be known as unwelcome to someone else. So by wearing all of this cologne and going into work every day, it really was unwelcome to everyone else. This also goes for situations where people take liberties they shouldn't take. I could actually go back to my own days in NCR, where I had a manager who used to punch me in the shoulder. Actually, he used to punch everybody, but he used to get carried away sometimes, and I would go home with black and blue on my shoulder, like, and pain you wouldn't even believe. And every day the same thing. It was just his way, like he called it a love tap. I think he was an idiot, but that would be considered to be harassment nowadays. Then it really nobody cared. But nowadays, that would be harassment. The other area, which is also really important here, is the verbal side of it. You can have the physical, and then you can have the verbal. You can even have other forms of visual. Let's say that an individual gives you a dirty look every time you go to work and makes noises or something like that. Well, that's the same thing. That's harassment. And you can't do that. That's inappropriate. There are situations where, let's say, the guys you're working with, they come up and they put their arms around you. That's harassment. You can't do that. And yet a lot of people just don't understand that. Verbal threats, intimidation is a big one for some companies. Jokes. A joke can be a joke, but sometimes it's taken out of context. And unwelcomed remarks and offensive pictures. Offensive pictures are a big one nowadays, especially with younger people. This is something the government is working on right now, is offensive pictures. You often see this, especially in the US, because they have serious issues with kids using social media to slam one another. Lots of kids in the States, I don't know if you're aware of this, but the statistics have gone up quite a bit of kids committing suicide. Excuse me. Committing suicide based on social media and people making fun of them. So this is something that they're really working on. Uh, Often the harasser doesn't even realize it. It's quite true. In many cases, it's just that's the way they are, or their family is like that. There are families in from specific areas in the world where they don't touch one another. And then there are other families in other parts of the world where everybody is hugging one another and holding one another's hand, and they don't think twice about it. So it's kind of when you bring people into a melting pot where everybody is a little different and they have different backgrounds that you often run into some of these situations. Sexual harassment is also an issue. So coercive vexation to the conduct, and it's simply based on gender that is known or ought reasonably to be known as unwelcome. So any kind of comment or whistling or eyes or anything that you would consider inappropriate in a sense is harassment. Sometimes you have to be a little cautious. You might think it's harassment, and the other individual may not even know you're there. I actually ran into this myself once. I was very focused on something I was thinking about, and somebody walked past me and was really angry that I was looking where I was looking. But I didn't even know they were there. So sometimes you get so focused on something, you just, it doesn't seem right. So, coercive vexation, offensive remarks, flattery. Flattery can actually be offensive, it can be harassment. Remarks about physical appearance can also be harassment, and inappropriate staring. This is what I was doing one day. I actually do that sometimes. I start thinking very deeply about something. I may not even know what's going on around me. Offensive jokes is another one, and display of offensive pictures. This also, I've had students who do this, and this is something that is very unacceptable. Questions or discussions about sexual activities. Again, you have to keep these things to yourself. Shop talk, defense usually doesn't work. I'll give you an example. I can't really give you a detailed example, but I'll give you an example. A friend of mine works in the airline industry, and every so often she has to go from Pearson to Hamilton, where they have a number of aircraft in both locations. These are the big jets. And she'll go there and do the paperwork, and then she comes back to Pearson again. But there's a big difference between the Hamilton crew and the Toronto crew. The Hamilton crew they use really interesting language. Like every other word starts with F. It's a very different group, but they all fit together. They're the right type of people to work together. Whereas in Toronto, you never hear the word F anywhere. Well, you might, I don't know. But according to her, it's quite an eye-opening experience to go to these two locations. That's what we would call shop talk, because fundamentally everybody does it, but not everybody wants to participate in those environments. And that's where it becomes necessary to ensure that it stops. Unfortunately, sometimes managers are the worst offenders, and they're not the ones to talk to. It's human resources we should talk to. Sexual solicitation is also unacceptable. Everyone has the right to be free from sexual solicitation or an advance made by a person and a reprisal or threat of reprisal for rejection of sexual solicitation. This has never been an acceptable practice. However, there are people who get carried away. You wink at them once, and the next thing you know, they're in love with you and they're humping your leg or something like that. I don't know. But you definitely have to be aware that not everybody is able to separate sexuality from, let's say, day-to-day operations or connection with other people. They don't socialize quite the same way. And usually it's a person of authority. So what they're talking about here is a supervisor or a manager looking for special favors in order to provide special favors. Again, this is totally unacceptable behavior. In these situations, you go directly to human resources and you talk to them. And if they're not willing to be involved, which they should be, they should do an investigation, and they shouldn't give you your name. They just do an investigation. And if they're not willing to do it, then you go to the Board of Labor and levy a complaint. This is another area which really needs to be understood better. Workplaces feel hostile because of insulting or degrading, or let's say in here, degrading comments or actions. There are situations where people pick on one another. I'm going to give you an example. I'm not going to name the company. It's a giant, but I know the CEO, and unfortunately, he made a serious mistake. Whenever he went into a department, some of the people in that department were picking on one of the students who was a little bit, students, what am I saying, students? One of the employees who was a little bit bigger than some of the others, kind of little heavyweight. And they used to call him all kinds of names. And one day they called him Tubby. And then they kept using the same thing because he probably didn't argue the point, or they decided to just simply go after him again and again. They used to do all kinds of stupid things, but they used to keep calling him this. And every time the CEO would walk through that department, he would hear people calling him Tubby. So, and since he never seemed to argue about it or never seemed to say anything, then it was one of those situations where people very quickly decided that this is his nickname. And there was a general meeting where they had just won a giant contract and decided to have all of the staff in to one of the main hangars. And when all the staff were in there, he drew attention to some of the people working on the project. And one of them happened to be in front of hundreds of people, Tubby. Okay, and it really, the guy was so upset, he walked out. And of course, the CEO then discovered that this was the wrong name. And he had to explain to the rest of the employees that they should never use these names or nicknames. Again, it can do a lot of damage. So you don't want to have a poison environment where you don't even want to work there or go into work. So comments and actions must be one that would offend a reasonable person. And again, that would definitely offend somebody. If somebody walked up to you and kept looking over your shoulder, that's a poison environment. You don't want to have people breathing down your neck, staring at what you're doing, making lewd comments or something like that, or just staring at you all the time. It's a poison environment. Making derogatory comments or giving you dirty looks or something, that's a poison environment. So anything that would make it difficult for you to achieve your particular function in that company, that's a poison environment. Employer has an obligation to monitor. Remember, they have a fundamental legal requirement to keep it a safe environment for their staff. And a poison environment is not a safe environment. People can become really agitated. They can become sick as a result of constantly thinking about what's happening around them. So you're supposed to watch this and deal with it as quickly as possible. So if you find something, eliminate it. Talk to the people, pull them aside, have a talk with them, figure out what the issue is and try to resolve it. So you're trying to prevent or respond properly to harassment, and you want to make sure no one is harassing anyone within that department. And as it points out here, failure to do so and the employer may be held responsible. In fact, you could find yourself not only fined heavily, but also spend jail time. Again, this is a very serious issue. So responsible for creating a poisoned work environment, you're definitely perpetuating it if you're not solving it. So you want to be participating to eliminate that possibility. And you take whatever steps. I would strongly recommend having, let's say, a meeting or having policy-driven systems that tell people certain behavior is not acceptable. So when it comes down to what is the ramification, employer liability for human rights violations, this is a term I want you to remember. When we get to the legal course, you'll remember this one again because we'll hit on it again. You have a vicarious liability, liable for the actions of its employees. The employer is directly responsible for what the employees do. So they are fundamentally, because of that contract, the employer contract with the employee, they are a direct connection to the company. They are theoretically and legally an agent of the company, which means there's a legal connection, a link between the two of you. So we call it a vicarious liability. In a harassment case, did they know about it? Did you educate them properly? Did you discover this? Did you actually try to discover what was happening? Or should they have known about it? In other words, is it something obvious you should know about? Or did they just decide not to tell anybody? Did they fail to act? In other words, did the manager decide, well, I'm not just going to do anything, I'll just let it blow over and we'll worry about it some other time? You have to react immediately. You cannot wait. Excuse me. So investigating, and we've talked about this before for human resource, when something happens, you must investigate it impartially. You don't worry about names, you just go looking for the facts. It's not what people have to say. You have to read sometimes between the lines. If an individual tells you something, you have to determine what about it is a fact and what about it is fiction. So investigation should be taken seriously and you should do it ASAP. Don't wait. When you wait, people tend to forget. They have short-term memories. They may forget after a day or so the elements that you needed to know. So act upon it as quickly as possible. And follow the employer's policies. Every company should have policies that literally deal with harassment in one form or another. And there should be absolute procedures available that you can follow so that you're not missing something that could be a legal requirement somewhere along the line. Insure investigator is got absolutely no interest in who wins or who loses. In other words, they have to be unbiased. You want to make sure there's no vested interest in one person being found guilty or the other. It doesn't matter. You're going to check into it with an open mind. So whoever is investigating has to do so with an open thought. Interview the third-party witnesses, but look for the real information in the background. Make sure that the witnesses are interviewed separately. Never do this together and don't let them sit together. Let's just say that you had to call 4 people in. Let them stay at their desk and then call them in when you need them. And don't let them go back and talk to one another. So one of the instructions, when you finish interviewing one, you send them back and say, please do not discuss this with anyone as I may be calling other people. And I do not want them influenced by what you had to say. So please keep it to yourself for the time being. You realize they're not going to, so you may have to bring in the next person right away. Ask non-leading questions. you really do have to think carefully. And I would suggest that you always do research to find out what kind of questions should I ask. Don't just try to ad hoc make it up on the spur of the moment. You want to have questions that do not lead the, let's say, the person being interviewed to a resolution. You want them to be open. So you ask them open-ended questions. You don't ask them anything that is leading to a particular conclusion. Let them come up with whatever information they're going to provide you. And dig deeper if you have to. You just have to make sure that you have no interest in whatsoever who wins or who loses. Just keep an open thought or an open mind, and you'll get more information that way. No matter what happens, both parties will have to be given a full opportunity in private to give their view of the story, whatever it happens to be. So they both get a chance to respond. And that response should be documented. You need to have a paper trail because it doesn't take much for somebody listening to what others had to say when they go back into the office environment to change their story. Okay? If it sounds better another way and everybody's been talking in one way, then they're going to change their story for sure. So you want to make sure it's documented. Everything should be documented. Take the whole picture into it. So the entire context needs to be evaluated and analyzed to see exactly what really took place. And document the investigation. A paper trail at this point is absolutely crucial, especially in the case of sexual harassment. This is an area where you definitely could end up with legal issues later on. So you want to make sure everything is documented. Some of the things that often take place in large companies is they may ask if they can either videotape or they can take a voice recording of the interview so that they have the information they can type up later. And they want to make sure that everything is accurate. So when it comes to promoting a harassment-free workplace, there are different types of behaviors that are considered harassment, and we need to take a look at each one of these. You need to encourage the employees to recognize and also report. This doesn't happen all the time. So you need to have an open and free environment where people feel it's okay and they're not going to have any kind of repercussions for speaking up. You want to make sure that they are speaking up and that they feel safe in doing so. Describe the penalties for violating a policy. You cannot hold anyone responsible for anything unless they know about it. So you want to make sure that you define it. Maybe make a meeting or a pizza meeting, like a lunch meeting for everybody, and then start talking about some of the problems that could exist and what are the penalties for doing this. Because sometimes people don't recognize that they are maybe the perpetrator of such a situation. Supervisors deal promptly with the allegations. You definitely have to make sure that the immediate supervisors are 100% active and that they're not sitting on the sidelines. They're actually taking a vested interest in solving the problem because, once again, one of the legal requirements is that a company must provide a safe working environment. And no one should know anything other than the person who you are talking to. They're the only person who should know what you're talking about. One of the things that you can take from how police are trained, I've actually trained a couple of police in the past. One of the things that they're often trained with is, number one, they're asked to introduce an idea that doesn't tell you what happened. So they're just asking you, what did you remember happening? But they don't tell you that somebody stole something. When police pull people out of, let's say, Walmart, you see a police car or something, they're probably taking them into the back room and asking them, what do you think we're here for? They're hoping that you will tell them so that they don't have to identify it. Because the worst case scenario is to accuse somebody of something they didn't do. Okay. And you don't want to allude to the fact that they may be the perpetrator, because sometimes you get it wrong. So you want to make sure that you're kind of leaving it open. What do you think happened at that particular day? So treat all the complaints totally confidential. Don't give anybody else's name to somebody else so that they can do a reprisal on them at some other moment. Okay. Prompt and thorough investigation. We just talked about that. Circulate anti-harassment policy information. If you have any form of harassment taking place that seems to have a little bit gotten out of control, it's time to immediately make sure that everyone knows the policies and they can also identify what harassment is. Sometimes, as I mentioned before, people don't always recognize it because of the cultural background. Different cultures are touchy-feely, other cultures are not. So sometimes what is appropriate within one group may be totally unacceptable in another group. So this is why it's important to bring everybody together instead of just one or two people. Bring everybody and let them know what the rules are. And this is what happens when they don't understand the rules. Everything goes blank. Fantabulous. Isn't that exciting? There's a lot of silence out there.
I'm here listening.
Good show. You passed. Hold on. I'm just giving you some files to look at. And it looks like, yep, it's there too. Okay, so I'm just going to give you a couple of files. Just give me a second here. In fact, I'll pull this over. It looks like Keston never showed up today. That's a shame. So there's a few things here I'm going to give you. One is a case. It's called discrimination. I'm just going to put it into the chat. And I'm also going to put another one in here, undue hardship. Now, undue hardship is a situation where a company is required to accommodate. If there is a reason that they need to accommodate, like I gave you an example, maybe a special keyboard or a special screen or something that would be unique for that individual, you cannot simply not hire somebody because they have poor eyesight. You would have to accommodate. You'd have to find a way of solving that issue. And it's the company that has to solve it. If the individual has a wheelchair or has crutches or some kind of impairment with their walking, you would maybe have to put a ramp in. So this means getting somebody to pour concrete or what have you and put a ramp to the building. You cannot discriminate against hiring the individual simply for some little disparity. You have to find a solution. But undue hardship occurs when you could not financially do it. And there are situations where that can happen. Those there, plus I'm giving you another one here, which is the guide to the rights and responsibilities under the code. So just throw that in there as well. Fantastic. And also questions not to be asked during an interview. These are things you should not ask during an interview. So I'm just going to put that there as well. Fantastic. So there are now 4 files.
So can you also add the PowerPoints?
Yep.
Please. Thank
I'm
you.
going to put that in as well. So we'll just put the PowerPoints in, 9 and 10. And this is part number 1 of 10. So there is another part that we'll deal with tomorrow. There we go. So what I'd like you to do is to work on those 2 that I just put in there. Let me just go back to that quickly. You're going to take a look at discrimination case study. And I also want you to look at the undue hardship case study. And then, of course, read the other 2 and do some study as well. Any questions so far from either one of you?
No, not so far. I'm
None
okay.
so far? Okay. How about you, Desiree? No? Okay. So what I'd like you to do is work on those, and I'm going to let you go. You can take your break and also work on that for the rest of the day. I'll be here till 5, so if you need me, just jump back in.
Okay, sounds good. Have a good afternoon, guys.
Yeah, take care.
Bye.
Fantastic.